3. We're here on a final hearing involving the Thomas child.
Ms. Novak, you're a St. Francis Ministries pharmacy specialist.
Yes.
In that capacity, you are familiar with Sophia Thomas, the child, the subject of this suit.
Yes.
She is 5 years old.
Yes.
Currently resides in a foster home in Randall County.
Yes.
And is that foster placement meeting all of her needs?
Yes.
Any special needs or special issues that have arisen with Sophia that we need to make the court aware of today?
Nothing current since the report was filed.
And is she doing well in her current placement?
Yes, she is.
Any concerns about her current placement?
No, sir.
Is that placement considered a long-term placement for Sophia?
Yes.
Have they expressed a possible interest in adopting Sophia?
Yes, they have.
Are they working towards becoming licensed so that they can adopt?
They are a licensed home, sir.
Okay, so this is a potential long-term adoptive home that Sophia is currently residing in.
Correct.
And it's stable.
Yes.
There's no criminal history in the home.
No, sir.
No history of substance abuse in the home.
No, sir.
It's a positive place for Sophia to be growing up and to live on a permanent basis.
Yes.
Child's mother is Selena Rice.
Yes.
Have you had any contact with Miss Rice?
Not since January.
January, what type of contact did you have with Miss Rice?
I texted her to let her know that I was the new worker receiving the case and I needed to go over her family plan of service with her. She responded a couple days later that asking for me to email her classes that she could do online. I responded a couple days after that back to her asking her to call me because I wasn't quite sure what she was referring to, and asking her to call me to go to discuss that and her family plan of services. And I have not had a response since then.
So you took over the case in the first part of January, is that right?
Yes, sir.
From that point until now, the only conversations or contact you've had with Miss Rice is a couple of text messages explaining that you were the caseworker and that she needed to complete some services.
Yes.
She has not tried to call you back. She hasn't texted you back. And as far as you know, she has not started any services.
Correct.
In reviewing the file prior to today's hearing, did you see that she had begun working any services prior to you becoming the caseworker?
She had did a parenting, online parenting class, but it was not, it was the, sorry, the type of class was not focused on the reasons of removal, so we did not accept the certification of that class.
All right, let's talk about the reasons for removal. What is your understanding of the reasons that Sophia was removed from Miss Rice's care?
It was neglectful supervision that she was found alone.
So, do your records reflect that Miss Rice had left the child alone in her home and that the home was unsatisfactory for a child of her age?
Yes.
Do your records reflect that Miss Rice has a history of substance abuse?
Yes.
And that she's actually had a history with Child Protective Services both in Oklahoma and in Texas?
Yes.
And she's had other children removed from her care?
Yes.
Specifically in this care, do your records reflect that the neglectful supervision that she was providing to Sophia put Sophia in danger?
Yes.
Would you agree with me then that Miss Rice then knowingly placed Sophia in conditions or surroundings which endangered her physical or emotional well-being?
Yes.
Would you also agree with me that the conditions that Sophia was in, that Miss Rice engaged in conduct which endangered the physical or emotional well-being of Sophia?
Yes.
At the beginning of the case, there was a different caseworker, but is it your understanding that there was a service plan that was put in effect for Miss Rice?
Yes, and it was mailed to her while she was incarcerated in September, and Miss Rice confirmed that she did receive it when she was incarcerated in November.
And do you have a copy of that service plan?
I do.
I want to go through specifically the requirements set forth in that service plan. Start at the top. What was the first service that Miss Rice was asked to do?
To remain in contact with the department in St. Francis.
And you've already testified that since January, you've only had one text message conversation with her.
Correct.
Does your records reflect that she remained in contact with prior caseworkers for St. Francis Ministries?
It was minimal. There was only a couple conversations that I reviewed.
Will you agree with me then that she has not remained in contact with the department or with St. Francis Ministries?
Yes.
All right. What's the next service that's on that list?
She would maintain a source of legal income and an adequate support for herself and the child to demonstrate stability.
Have you seen any evidence, either to you personally or to your prior caseworkers, that Ms. Rice has a stable form of income?
No.
What's the next service on that service plan?
Ms. Ricewood is allowed visitation with her child as a mutual agreement upon St. Francis. Virtual visits were offered and set up in November, and Ms. Rice made no contact to confirm or to attend visitations.
So when was the last time that Ms. Rice had actual face-to-face contact with Sophia?
It would be at the time of the removal. I don't know for sure if there was
Okay.
anything after that, sir.
But for at least 6 months?
Correct.
When was the last time that your records reflect that she's had any virtual contact with Sophia?
She has not had any that I know of, sir.
Would you agree with me that she has not had regular visitation with Sophia or any significant contact with Sophia since the removal in September?
Correct.
For the record, today is May the 9th of 2025.
Yes.
Is that right? And what day does your records reflect that Sophia was removed from Miss Rice?
August 1st, 2024.
And since that time, Sophia has been in the temporary custody of the Texas Department of Family and Protective Services?
Yes.
All right. So what's the next service after visitation on your service plan?
That Ms. Rice should participate in probation services and requirements given to her by her probation officer.
Are you aware if she is still on probation?
I don't know if she is, sir.
She's not made contact with you and you haven't been able to determine whether or not she's still on probation, what the status of her probation is.
That is correct.
Would you agree with me then that she has not satisfactorily completed that service also?
Yes.
She hasn't demonstrated or provided us with evidence that she's completed her probation.
No, she has not.
What's the next service on that list?
Ms. Rice will actively participate in court-ordered services and follow recommendations of the providers.
Court-ordered services would be the service plan that she's been ordered to complete.
Correct.
And would you agree with me that those are reasonable and necessary steps that the court has ordered for Ms. Rice to complete in order to have Sophia return to her?
Yes.
And she has not completed the service plan as we're going through it today.
Correct.
All right. What's the next step on her service plan?
At the request of St. Francis and/or providers, Ms. Rice will cooperate and sign any necessary releases of information.
Do you know if she has provided any release of information for us at this time?
She has not, no.
What is the next service on your service list of services?
Ms. Rice will maintain a home that is safe, stable, has all working utilities free from drugs and violence.
All right, let's talk about her home. Do you know where she's living today?
I do not.
You've not had sufficient contact with her since January to determine what her living environment is.
Correct.
So would it be difficult for you to say that she has provided evidence of a safe and stable environment?
I'm sorry, can you repeat that one?
Can you tell us whether or not she has provided evidence of a safe and stable environment?
I cannot. I don't know if she has, sir.
What's the next service on your list?
Ms. Rice will complete a drug and alcohol assessment.
Has she done an OSAR evaluation or something that is similar to an OSAR evaluation in Oklahoma?
Not that I know of, no.
She hasn't provided you with any documentation that she's done that.
No, she has not.
What's the next service on your list?
Ms. Rice will maintain a drug and alcohol-free lifestyle and abstain from the use of alcohol, illegal drugs for which she does not have a valid prescription for, or other mind-altering substance such as,
All right,
but not limited to.
All right, we don't have to go through all those, but specifically, she's supposed to remain drug-free.
Correct.
And in order to be able to determine if she's drug-free, she has to do random drug screens.
Correct.
Does your records reflect that prior to January, when you took over the case, that she had completed any random drug screens?
She had not, no.
And since January, when you took over the case, has she completed any random drug screens?
No.
Have you attempted to contact her monthly so that you could ask her to do a random drug screen?
Yes.
But she's not been available to you at all.
Correct.
All right, what's the next service on your list?
She would participate, Ms. Rice would actively participate in individual counseling with a provider and follow recommendations of the counselor.
Do you show either before or after you became the caseworker that Ms. Rice has completed any counseling?
No.
All right, what's the next service?
Ms. Rice will participate and complete in a psychosocial with the therapist.
Has she completed a psychosocial?
No.
What's the next service?
Ms. Rice will actively participate and complete in rational behavior therapy.
Has she completed an RPT class?
No.
What's the next service on your list?
Ms. Rice will attend and participate in a parenting class.
And your testimony earlier was that she completed a parenting class, but it wasn't satisfactory to focus on the reasons for Sophia's removal.
Correct.
What's the next service, if any, on your list?
That's all of them, sir.
Would you agree with me that Ms. Rice has constructively abandoned Sophia to the Texas Department of Family Protective Services?
Yes.
In the fact that she is, that the department, yourself, your prior caseworkers for St. Francis Ministries have made reasonable steps to attempt to try to reunify Sophia with her, but she has not complied.
Yes.
And that she has not regularly visited or had significant contact with Sophia.
Yes.
She has not demonstrated that she has a safe and stable environment for Sophia to come home to.
Yes.
It's been more than 6 months since the department has had temporary custody of the child.
Yes.
Will you also agree with me that she has failed to comply with the provisions of a court order that specifically established actions necessary for her to obtain Sophia in her care?
Yes.
And that it was her own actions which caused Sophia to be removed from her.
Yes.
And it's been more than 9 months since the child has been in the care of the department.
Yes.
Do you believe that it's in the best interest of Sophia Thomas at this time for her mother's parental rights to be terminated?
I do.
Why?
Because she's failed to work services and abandonment of Sophia.
Would it also be positive for Sophia because of the stable environment that she's in and will possibly be in on a long-term basis?
Yes, sir.
At the first of this case, Ms. Rice informed the department that Sophia's father was deceased.
Yes.
We've attempted to confirm that. We've found a name in an obituary, but we cannot confirm or have not been able to confirm that it's that particular person who is the father to Sophia.
Correct.
But we believe that Sophia's father is deceased at this time based upon what Ms. Rice has told us.
Yes.
In the meantime, we did a paternity registry search. No one has claimed to be Sophia Thomas's father at this time.
Correct.
Nobody during the length of the time you've been involved in this case has reached out to you claiming to be the father to Sophia Thomas.
Correct.
And as far as your review of the record, nobody has reached out to any St. Francis Ministries caseworker to claim that they are the father to this child.
Correct.
Are you asking them that, or do you believe then that it would be in the best interest of Sophia Thomas for any unknown fathers to be terminated at this time?
Yes.
We've talked about a number of steps that you've taken. Has St. Francis Ministries taken reasonable steps in an attempt to reunify Sophia with either parent prior to today?
Yes.
Those steps include trying to maintain communication with Ms. Thomas, providing services for Ms. Thomas, developing a service plan with Ms. Thomas. Your prior caseworkers were in contact with her when she was in jail and provided her with a copy of the service plan. Would you agree with that all of those things were reasonable steps in an attempt to reunify Sophia with her mother or with an unknown father?
Yes.
Are you asking then that all parents' parental rights be terminated today and that the Department of Family Protective Services be named as a permanent managing conservator of Sophia Thomas?
Yes.
I'll pass witness Cheryl.
All right, thank you, Mr. Barfield.
Ma'am, did Miss Rice ever take and fail any type of drug test ordered by this court?
I don't have record that she ever took one, sir.
Okay. So as we sit here today, we don't know, we just don't know whether she would be using drugs or not. Is that a fair statement?
Yes.
Do you know, did you have an address for her as we sit here today, current?
I do not. I ran a search for her and it came back with her mother's address.
Did any communication or letters go from the department to that address asking her to contact the department?
No, sir.
Okay. Is the main, when you sent text, did they seem to go through to her phone, or did they come back undelivered?
They all appear to be delivered.
Okay. Can you recall her responding to any of your text, say within the last couple of months?
No, the only one was in January, sir.
Okay. And I'm assuming you've had no phone contact with her.
No, I've tried. I've left messages as well. And she has not picked up, sir.
Did you or anyone else, to your knowledge from the department, make contact with her parents to see if they knew where she might be?
Yes, I did myself in January, and her mother told me that she didn't know where she was living, but she would let her know that I was trying to contact her. And I believe the previous worker also had contact with her mother.
Okay. Do you know, so as we sit here today, do you know if she's living in Texas or Oklahoma?
From what I understand, she's living in Oklahoma.
Okay. Would that still be Beaver, Oklahoma?
Yes, sir.
Okay. Now, you talked a little bit about probation. Do you know what she's on probation for?
I do not.
Did you or anyone in the department, to your knowledge, make contact with the probation office in Beaver, Oklahoma to see whether she had completed probation?
The previous worker did, and she was told that she needed to release the information to talk to her, and Miss Rice did not sign one of those for us to be able to communicate with them.
Okay. Was it requested that Miss Rice sign one of those releases so that the department could contact the probation office?
I believe so, yes.
Would you, so basically, would you say that Miss Rice has wholly failed in her efforts to mitigate the reasons for removal?
Yes, sir.
Okay. Now, Sophia, this child she's 5 now?
Yes, sir.
Okay. And is she doing well in placement?
She is.
Okay. And there was a CASA report filed in this case. Did you have a chance to review it?
I did not, sir.
Okay. All right. Then I won't ask you about it. What is the goal in this case to get Sophia in a place where she can be adopted?
Yes, this is a legal risk home, and they intend, if rights are terminated, that they can move forward with adoption.
Okay. So they already have the legal requirements in place to provide stability?
Yes, sir.
Okay. Is there anything that you could think of that would change your opinion that you've stated to this court regarding termination?
No, sir.
Okay. I'll pass the witness, Your Honor.
All right, thank you, Mr. Nowak.
Thank you so much, Judge. Ms. Novak, it's always good to see you. And I'm Vince Nowak, not Tracy Riley today. Ma'am, I just have a couple simple questions. What efforts have you or the department made to locate the unknown father or unknown fathers?
Just from what Mr. Alvey has done, sir.
And to your knowledge, what has Mr. Alvey done to locate unknown fathers?
The posting, the search for the unknown father.
What does that entail?
To be honest, I don't know, sir.
That's fair enough. Fair enough. Judge, I'll pass the witness. Thank you so much, sir.
All right,
Ma'am, thank you, ma'am.
Mr. Harris?
Your Honor, thank you. Just briefly, Ms. Novak, do you believe allowing the child to remain in current placement is in her best interest?
I do.
And do you further believe that terminating the rights of the mother and the unknown father to allow the current placement to adopt the child is in her best interest?
I do.
Thank you, Your Honor. Pass witness.
All right. Mr. Alvey, anything further from the department?
No, not at this time, Your Honor. We would rest.
All right, thank you. Mr. Barfield, any witnesses?
I have no witnesses, Your Honor.
Mr. Nowak?
No, sir.
Mr. Harris, any witnesses?
None, Your Honor.
All right, Mr. Harris, recommendations?
Your Honor, based on the testimony presented today, I believe that it's in the best interest of Sophia Thomas for the parental rights of her mother, Selena Rice, to be terminated and to terminate the unknown father's parental rights to allow the current placement to move forward with an adoption.
All right, thank you. And Casa, anything to add?
No, we are very pleased with Sophia's placement. She seems to be making great improvement and thriving in this placement. We are in approval of the adoption.
Okay, all right then. Ms. Novak, one other question I had.
Yes, sir.
Would you say that the creation of the service plan and trying to facilitate visits with the mother, were those reasonable efforts on the part of the department to reunify the child with mother?
Yes, sir.
Okay, all right, thank you. Okay, then. Then based on the evidence I've heard today, as well as the exhibits that have been admitted, I do find that it's in the best interest of the child, Sophia Thomas, that the parental rights of the mother, Selena Rice, be terminated. I'll terminate those rights today based on Texas Family Code, section 161.001, subsections B1D, E, N as in Nancy, and O. I further find that it's in the best interest of the child, Sophia Thomas, that the parental rights of any unknown father be terminated. I'll terminate any unknown father's rights today based on Texas Family Code, section 161.002, subsection B2, as well as the paternity registry search, which is on file and which has been admitted as an exhibit today, showing that no one has claimed paternity of Sophia. I'll name the department permanent managing conservator, continue Sophia's current placement. Does Ms. Cheney or Ms. Williamson, does Casa want to stay in this case or be dismissed?
I'll stay
would
in,
like to stay.
Judge.
Okay, all right. Then I'll continue Mr. Rick Harris as the child's attorney ad litem and Casa in this case. All other court-appointed relationships will be dismissed after all appellate and de novo periods have expired. All right, then we will have, I don't know that I have a date on here. Leslie, do you know, well, we have a date for our first review hearing? You happen to know, or Brittany, either one?
I looked and August 6th would work. It's a day before the 90th day.
Okay.
Yeah, that works for us.
Okay.
Thank you, Leslie.
All right, then I'll set our next review hearing for August 6th, 2025. That will be by Zoom like today's hearing, so parties can go on the court's online docket a day or two before August 6th to see exactly what time of day we'll have that hearing. All right, Mr. Abbott, this is the only hearing I had with you, and I don't have any other hearings until 1 o'clock. I've got 2 Randall County hearings this afternoon, so I'm going to go ahead and end the Zoom. I don't think any of you are involved in those cases, but excuse me, but I will, I'll start the Zoom again shortly before 1 o'clock this afternoon.
If it please the court, Your Honor, if there's a possibility that I could talk to Mr. Novak and Mr. Barfield briefly in either a breakout room or without others present. It's really not about this case, but it's about something else that I need to talk to them about.
Yeah, I'll set up a breakout room and I'll just watch when you all sign off, then I'll cut the Zoom.
Thank you, Judge.
This is a motion for leave to intervene, and I have that there has been a motion to strike filed by the mother. This is involving the Warren children. All right, Ms. Wiggins is not with us. Mr. Pirtle represents the father, Mr. Warren. Mr. Pirtle's not with us, nor is Mr. Warren. Ms. Lucero represents the mother, Ms. Lancaster. Ms. Lucero and Ms. Lancaster are with us. Mr. Hamker represents the potential intervenors, the Lopez's, Joshua Lopez and Tina Lopez. They are all with us also. Ms. Wiggins, what she sent me, I'll read it now and then we can get started. She says, Courtney's recommendation for that hearing is that she does not have any objection to the intervention of Bill's clients, the Lopez family. That's all she said. Mr. Hamker, you filed the motion for leave to intervene. There, as I said, Ms. Lucero has filed a motion to strike, so I guess the burden goes back to you. Do you have witnesses or just legal argument?
Your Honor, I just have one witness.
Okay. Who's that?
Joshua Lopez.
Okay. Mr. Lopez, if you'd unmute.
Yes, sir.
Thank you, sir. If you'd raise your right hand.
Yes, sir.
you swear the testimony you give will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right, Mr. Hamker.
Mr. Lopez, your wife is there with you, correct, Tina?
Yes, sir.
And the two children, Chloe Warren and Bud Warren, are they currently living in your home?
Correct. Yes, sir.
How are you related to them, Joshua?
I'm their uncle, paternal or uncle through maternal uncle through my mom's side.
All right. And am I correct that they've been living with you and your family since the 15th of December, the year 2023?
That's correct.
Okay. And they're going to school?
Yes, they're actually excelling in school. They're doing very well in school.
Okay. Now, are you all, I was thinking that you all had already been licensed as foster parents, but it's my understanding that the department still has two things they're working on with you. Is that correct?
Yes, we have to do the health assessment, and then we also have to do the fire assessment, but we've done everything else asked of us.
All right. Now, the children, they're having visits currently with their mother occasionally, correct?
Yes, sir. On Tuesdays for 2 hours.
For 2 hours. When they come back from their visit, do they manifest any problems?
They seem a bit tired and agitated. Just a little frustrated with the situation.
How can you tell of the frustration?
Just by their demeanor. They're always, when they're waiting by the door every day for that visitation, it's important to them, the 2 hours, and then they just come back very exhausted and just kind of emotionally distressed, and it takes them a little bit to readjust after visitation.
Have you become aware of any contact or any comments from their mother to them that would give you concern?
Yes, bringing
Your
up.
Honor, I'm gonna object to hearsay, Your Honor.
Is it from the children?
What I was about to say.
I'm sorry, I was reading this objection and motion strike that I just got. Hearsay on who? What was your, Mr. Hamker, repeat your question. I'll pay more
Yes.
attention.
Have you ever been told by anyone that the mother was encouraging them to shoplift?
Yes,
Let's be real picky here. The question is, have you been told by anyone? You can say yes or no, but I'm not sure yet if you can say what you were told.
Okay. Yeah. Yes, sir. Sorry.
Okay.
Thanks, sir.
Is the department aware of that, to your knowledge?
I believe so.
All right. Do you think that their emotional development in your home is going well?
Yes.
Okay. Do you think that after witnessing the after effects of the visits of the children with their mother, that their emotional development would go well with her?
No.
I'm gonna object to speculation, Your Honor.
Sustain.
Has the oldest girl ever exhibited head banging against doors or furniture after visits with her mother?
Yes.
Have you noticed any of that type of conduct with respect to Bud?
Not so much. No.
Okay. As long as they're in your home, have they been physically healthy?
Yes.
You have retained me to file legal papers attempting to become parties in this case. Is that correct?
Yes, sir.
Do you think that that would be good for the children?
Yes.
Okay. They're not young children. How old are they?
The Bud's about to turn 12 and Chloe's 14.
are they aware of what's going on in this case?
Yes, we've explained it to them the best we can, to, a child.
Uh, has their attitude improved since they've been in your home?
Yes.
Are they positive?
Yes. Yeah.
Do they talk about the future?
Yes, sir. Chloe, can I elaborate or do I need to keep it short?
Or tell me about what they talk about.
Okay. Chloe, when she first had arrived, she said, well, if I can go
Object
to
to
college.
hearsay.
No, kids are parties, so you can go ahead, sir.
Okay. She said, basically, if I go to college, and we told her, when you go to college, have a positive outlook. And we've even found letters that she's wrote, when I go to Baylor or I go to WT, I'm gonna, she wants to be a teacher. I mean, at that age, they want to be a lot of things, but she has a very positive outlook on life. And Bud, he does very good in school. He had a speech problem, and he also has dyslexia, but he's been released by both of those. Tina just went to his art this week, and he was released, so he doesn't have to be under those restraints anymore.
So they've excelled personally since they've been in the situation that they're in.
Yes, sir.
Okay. Do you think it would be in their best interest that not only they stay in your home, but that you all be allowed to be parties to the case?
Yes, sir.
Okay. I'll pass the witness, Your Honor.
All right. Ms. Lucero, do you have any questions?
Just a couple, Your Honor. Mr. Lopez, when y'all became involved with Elena's children, well, I know y'all are relatives, but when they came to live in your home, Chloe, Kelsey, and Bud came to live with you. Is that right?
Yes.
Okay. But currently, Kelsey is in an RTC in Lubbock. Did you know that?
Yes.
Okay. And so your petition to intervene only includes Chloe and Bud. Is that correct?
Yes.
Okay. Do you think it's in the children's best interest to split them up like that going forward?
Probably not.
Would you agree with me that in your conversations with the children, they've expressed to you that they want to go back home with their mom?
If mom's in the right state of mind.
You stated that whenever it's time for the kids to go visit Elena, that they're by the door and they're excited, correct?
Yes.
Now, when they come back, you said that you have concerns or something like that due to their behaviors, right?
Well, they come back just tired, exhausted. Their demeanor changes.
Okay. Would you agree with me that it's possible that they're missing their mom and they just, and they, not that they don't love y'all, that's not what I'm saying, but maybe they're sad that the visit's over and they're missing their mom? That's possible, isn't it?
I would say, of course, yes.
Okay.
That's their mother, so.
I'll pass the witness.
All right, Ms. Gutierrez, any questions?
I have no questions, Your Honor.
Okay. That's probably good because I haven't heard anything yet that has to do with whether or not this intervention can go forward. We don't have a motion on file to change placement or anything like that. So, does anybody else have any witnesses or are we down to just legal arguments?
I have no witnesses, Your Honor.
Ms. Lucero, any witnesses?
No witnesses, Your Honor, just my legal arguments that I've already set forth in my motion to strike.
Oh, Your Honor, let me call Tim Koval very briefly.
Okay,
I'll
sure.
ask one question.
Okay, all right. Mr. Koval, if you'd unmute. Oh, you're unmuted. You swear the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. Ms. Gutierrez?
Thank you, Your Honor. Tim, we are the sole managing conservator or the permanent managing conservator of both Chloe and Bud Warren. Is that correct?
That's correct.
And are we in agreement with the Lopez's filing suit in this case?
Yes.
And do we consent to their filing for a modification in this case?
Yes.
Okay, pass the witness.
All right, thank you. Anybody else have questions for Mr. Koval?
No, Your Honor.
Okay. All right, then, Miss Lucero, I've read your motion to strike. I basically would, your main point is that this is not a pending suit? Is that the crux of why?
Yeah, yes, Your Honor, just that just some of the allegations set forth in their petition, it stated yes, it's not, there's no live pleadings pending, Your Honor. This case is we're under a final order. Granted, we have review hearings every 6 months, but it's not a pending suit. They had filed under also 102.004B and B1, and that's leave to intervene into a pending suit. They'd also filed under 102.003A12 as set forth in my motion to strike regarding foster parents, Your Honor. But as set forth in their testimony, they're not technically foster parents as of yet, so, Your Honor. So I would just ask that their motion be stricken.
Okay, I'm not in agreement that just because I think they'd qualify as a foster parent. And by the final order in this case, I think that that's in and of itself, the fact that neither parent was named a permanent managing conservator is proof enough that the appointment of the parents as or permanent sole or managing conservators would impair the physical health and emotional development of the kids. I think that's inherent in what I found at the final when I did not name the parents as the managing conservators. So I think it really comes down to the question, and I don't know the answer, is this still a pending suit after a final order? Because we have to have reviews, and that's what I want to hear about. And I'll give anybody who wants to an opportunity to brief it. But
Your Honor, I do agree. I'll jump in. I do agree with Ms. Lucero's analysis of where we are procedural, that there's not a pending suit. And but I think since Texas liberally construes pleading based on content, I think that the pleading could be considered a modification instead of an intervention, because the content is them asking to be conservators of the children. And I know he doesn't plead the right standing ground exactly. I think he has standing under 102.004 section A. I mean, not only would naming the parents managing conservator be a danger to the children, but the department has consented on the record to them filing suit in this case. So I think my legal analysis is that this pleading could be construed as a modification. It still doesn't cite the correct standing statute, but I think we could give them an opportunity, or I asked the court give them an opportunity to amend and correct that standing ground if they feel that would be necessary.
okay. Mr. Hamker, this is kind of your burden of proof, so you want to weigh in on why you think it's a pending suit?
Your Honor, the reason why I think it's a pending suit, and that is what color is the horse? Is it a gray horse or a black horse or a white horse or whatever? I think in my mind, a pending suit is a case to where there are still currently live pleadings in effect, and it is still susceptible to change and modification by the parties that are in it. It has not been, quote, disposed of, and I think that still makes it a pending suit. Now, it's not like a lot of other suits, as you said, but I think the fact that the parents are not managing conservators, but possessory conservators, I think that also lends credence to the fact that this case is still ongoing, still has hearings, still has all the attorneys that have been appointed by the court are still active in the case. And that's my position, that at least at this point in time, that it is still one where things are going to be conducted on. And
Right.
And with respect to the other points, I didn't get Lorraine's pleading until late yesterday evening. I didn't see it till this morning when I came in. It's probably not even gotten anybody. I filed a second amended petition to where I also pled these people in as people who just have had the children more than 6 months. I agree. I do not have the A part pled in this case. That will be could be the next thing that I plead, but I asked the court to liberally construe my terminology requesting for conservatorship in this suit to allow me to, on the record, amend my pleading to include 102.004A to save that complexity and extra paperwork.
All right.
Yes, sir. If I may,
Uh-huh.
I did have a, if the court would allow me to send it after this hearing, withhold its ruling. I did have a case, I'm sorry, I've had computer issues that's nearly on point as far as whether this is still a pending suit. It's a
Okay.
case where the same type of situation. CPS was named a sole managing, parents were possessory conservator, but it was considered still a final, it wasn't an ongoing pending suit. So if the court would just allow me time to get that, like I said, I had computer issues. Now, as far as Mr. Hamker's request to amend to 102.004 A, Section 1 states the order request is necessary because the child's present circumstances would significantly impair the child's physical health or emotional development. I don't see how that's applicable here. If the interveners, that's where the children are, so their current and present circumstances, I don't see how that's going to, impair the children. Now, it does say or number 2, where I guess the custodian in this case would be CPS or the department has consented to the suit. And I guess if you accept their consent at this time, Your Honor, that would cover them on that issue. But again, my argument is still that it's not a pending suit, Your Honor.
That's really, that's the main thing that I'm curious to see.
And
what
Your
the
Honor,
laws
if
are.
I may respond as well.
Well, let me finish though.
Oh,
I
yes, sir.
don't buy the argument about 102.004A1.
Okay.
I've had that come up before.
Okay.
So, but it comes down to me, the one thing that I don't know the answer to is if there's case law that says whether because we continue to have hearings after the final order, if that makes it a pending suit. I guess under that rationale, every suit affecting parent-child relationship until all the kids have turned 18 would be a pending suit. So I put this right along beside that, and I don't know the answer to it, but yeah, I'm going to give you time to provide that to me. I'm going to give all of you time to brief it, and then I'll make a ruling. So, Ms. Gutierrez, you had something else?
Yes, Your Honor, I did want to, I think another basis for that final hearing in a CPS, even if the department is named permanent managing conservator, if it's construed as a live pleading ongoing, I think that affects the stability of the children. That means at any point after a final order, even if the case is in appeal, somebody could be trying to intervene. And I think that compromises one of the goals of a CPS case and one of the goals for the children of creating that stability. So I'd really like to see Ms. Lucero's case law as well. I am in agreement of her procedural analysis of where we are. I think a live pleading is a live pleading, and when we've got a final order, it's done. And I think that there is court oversight over the department's conservatorship of the children. And yes, the court makes orders as necessary on an ongoing basis of that role. But I think that's distinguishable from a live pleading in place.
Well, so, but your witness testified that the department doesn't object to the intervention. Now it sounds like you're saying it is not a pending suit.
Your Honor, we don't object. How do I explain this? We don't object to him filing a suit. We don't object to the intervention. We do think that, I think that it can't be an intervention because there's not a live pleading. And as I was saying earlier, I think that in Texas, under our civil law, we liberally construe pleadings, and the content of his pleading, I believe, is the basis for a modification. And I think that as a modification, it can be a pleading. And in that sense, as a modification, we don't object to it, and we have consented on the record for
Okay.
that.
All right, so then what, if no one else has any further arguments, then I'm gonna allow 2 weeks for anybody that wants to submit some case law on on both those points then. Number one, is it a pending suit when we've had a final order and and that's a good way to put it, Ms. Gutierrez. The court is just really providing oversight. So, and then the other point would be if you want to brief, if your argument that it's akin to a modification. So, and I can't keep Mr. Hamker from repleting to add the 102, whatever it was, 004A. So, if he does that, then if we have to have if somebody files another motion to strike, we'll come back. But if you want to go ahead and brief that now, it might save us some time later. But that's the two issues I have. I don't have a problem that there's been substantial past contact. So, I'll give,
Your
we'll set it
Honor, if I may, I'll be glad to brief those as well, but I've got a daughter getting married next week and I'm going to be gone for a week or two. So I may be the last one to file my brief.
Okay. All right. Well, we'll see when we don't have a hearing set till June 30th as our next hearing. So I'll make that 3 weeks, Mr. Hamker, so you don't have
Thank
to
you.
rip that
That'll
up.
work perfect.
I don't know, Brittany, I don't have my calendar in front of me. What's 3 weeks from today?
Let me look at my calendar.
The 30th, May 30th.
Okay. All right. I'll just say that the briefs are due by 5 o'clock on May 30th, and then I'll read those and then I'll notify everybody of my ruling today by email. So.
Thank you, Your Honor.
We'll be in recess on this case. I will be back in 15 minutes to call another Randall County case. That's a petition to reinstate parental rights on the Lesnar children. So we'll be in recess for about 15 minutes. Y'all have a good weekend.
You too.
Thank you, Your Honor.
Thank you.
May I ask, is the Lesnar one going to be aired on YouTube?
I don't think so.
If I may have permission to stay in just in case there's a future hearing, I can make sure I add that to our dockets.
Sure. Is it not? Oh, that's right. Ms. Surratt's covering that, correct?
Yes, Your
Yeah,
Honor.
you can, you're welcome to stay in.
Thank you.
Okay, I'm getting ready to call the petition for reinstatement of parental rights in cause number 71833 L1 involving the Lesnar children. Was Lesnar children, not Lester anymore. Before we get started, Mr. Hill, if you represented Miss Lester originally, correct?
Judge, I did, and then she opted to represent herself, if
Okay.
memory serves me correctly, and you left me on as standby counsel.
Okay, all right. So for purposes of today's hearing, Miss Lester is now treated as a kinship, so she's not entitled to a court-appointed attorney. So you're not bound to stick around if you'd like to go. I felt like I had to notify everybody just so if anybody had any information that the court thought it should hear, that's why you're here, but you're not bound to stay here.
Judge, I'm here. I might as well stick around.
Okay. All right. Okay. You won't be asked to participate unless, you're called as a witness. So,
Okay.
okay. Thank you for showing up.
Yes, sir.
Okay. I will call the case again. We've talked about Mr. Hill, why he's here. Ms. Surratt is here representing the department. Mr. Novak is here representing the children. He was appointed for purposes of this hearing as required by the statute. And again, Ms. Lesnar is with us. Okay, before we get started, Ms. Surratt, you had a motion to dismiss. Did you have any exhibits you wanted to introduce? I think we can take up that motion to dismiss first because I think it's going to be dispositive of today's hearing.
Yes, Your Honor. I sent out exhibits 1 through 4 or 5 to the parties. I sent that out yesterday, and I would move to admit petitioners exhibits 1 through 5. As far as the motion to dismiss, it is it is a bar to filing the reinstatement of parental rights under 161.302 B3 if the children have been adopted and these four girls have been adopted, and that's in petitioner's exhibit number 1.
Okay. Ms. Lessner, do you have any response to that?
I don't know why I was muted, but I would object to allowing the state to have a dismissal knowing that my parental rights were illegally terminated. It doesn't matter how you cut the cheese on the rights terminated. The state asked the jury to terminate my parental rights simply because my husband at the time was accused of a crime. You cannot, under Texas state law, terminate parental rights on someone else's accusations. They had to find some kind of lawful reason to have me terminated from my parental rights, and they did not. The state has made those claims, and I have taken it up with the Department of Family and Protective Services in the commissioner's office. And they are the ones who told me there were no findings of guilt on my part, and I should have my children. Jerome Green stated that I should have possession of my daughters back in 2020 and asked me if they were at my house. And I told him no, they were not in my possession.
Let me interrupt you. Your rights were terminated. From what I read, that went to the seventh court.
Wrongfully.
Excuse me, don't interrupt me. That went to the Seventh Court of Appeals, and it was affirmed on November 26th of 2018. A petition for review was denied by the Texas Supreme Court. On June 3rd of 2019, the mandate issued. So your rights are terminated. And if you don't understand what Ms. Ratt was saying, the statute that allows you to ask for reinstatement of your parental rights, you must prove to the court that the children have not been adopted and the children are not subject to an adoption placement agreement. Plus, you have to have given notice 45 days prior to filing your petition to the department. These exhibits that have just been admitted show that the children have been adopted, and they show that you did not give 45 days notice of the filing of the petition prior to filing it. You gave the notice on the same day that you filed the petition.
No, sir, I did not.
Well,
I gave that notice in December, and I have proof of that.
According to let me interrupt you. The children are adopted. Unless you can convince this court today that the children have not been adopted, I have no choice but to dismiss the case. That is a prerequisite to you to even file the petition.
They were adopted illegally.
Okay,
what do you want me to say about the illegal part of terminating my rights?
That is not what the statute says.
Does not the state of Texas say that they support fundamental law? If the state of Texas does not support fundamental law, then I wouldn't be arguing the fact that the adoption was done illegally. They never found a basis to terminate my parental rights. I'm
sorry, I'm going to interrupt you one more time. The statute says you cannot file that, or it'll be dismissed if the children have been adopted. It doesn't say that the children have been legally adopted or illegally adopted.
So you're saying an illegal action can be done in a court?
I'm saying what I just said. The statute says if the children have been adopted, then I have to dismiss your petition for reinstatement, and that's where I'm standing. So that's my intent today.
If you dismiss this, Judge Graham, Associate Judge Graham, I should be seeing a judge who has standing. You are an associate judge. You are just a lawyer. Do you understand that you right now are violating my constitutional rights as you did 8 years ago?
No, ma'am, I don't. So again, unless you can present evidence that the children have not been adopted, I'm going to dismiss the case right now without any further testimony because the exhibits that have been admitted show that the children have been adopted.
And the other exhibits stating that I did not file are not proving that I did file 45 days? That's not the state lying right there.
Petitioner's Exhibit 2 is a certified copy of your notice of intent to file this petition. It was filed on March 14th, 2025 at 8:51 a.m. Your actual petition for reinstatement was filed on March 14th, 2025 at 8:51 a.m. So yes,
That is incorrect.
well,
On
that's,
December
that-
30th,
you can take that
my-
up with, excuse me, you can take that up with the district clerk because they have certified that these are accurate records. So
if
Mr.
you,
Nowak, you want to weigh in on this? You represent the children. Do you have recommendations for the motion today?
I do, Judge, and I so appreciate your temperament and your patience. Mom's rights were terminated, the kids were adopted. I'm not going to disrupt that adoption because some crazy lady has some crazy theories.
excuse me?
I apologize for that, Judge. My recommendation to the court today is to dismiss whatever mom has filed. And Judge, I do apologize for my commentary earlier.
That's fine. Okay.
It may be fine to you, but that's defamation of character, Judge.
Ms.
Yeah,
Lexner?
well, you know what? I'll defame your character all day long, lady. Judge, that's all I've got.
Ms. Lessner, the court finds.
Judge, can I confirm something real quick,
Sure,
Judge? Did
yeah,
did you admit my
Oh, I
my
haven't,
5
no.
exhibits?
Are there objections to 1 through 5?
And I named them departments, exhibit 1 through 5, since I guess Mrs. Lessner is actually the petitioner in this
Yeah.
particular situation.
Okay.
So
Well,
no objection, Judge.
all right, petitions
course
1 through 5 are admitted. The court finds that based on department's exhibit number 1, that the children were adopted.
Illegally,
And the
under
order-
the table. I never got the adoption
Thank you.
papers because they knew back in the day I would have argued that
Ms.
till the
Lessner,
cows.
I'm getting ready to mute you if you interrupt me one more time.
Oh, but you can interrupt me, right?
The order granting adoption was signed. It's in cause number 78010-L1 in the county court at law number 1. That order was signed by Judge Anderson on June 10th, 2020. And I'm looking at a certified copy of it under Department's Exhibit 1. Court finds that Ms. Lessner has not met the basic requirements to go forward with this petition because the children have been adopted. Therefore, I'm going to grant the motion to dismiss. All right, Ms. Lessner, you have 3 days, working days from today to file a de novo if you'd like for Judge Anderson to rehear this case. You have 20 days after I sign the judgment when it's presented to me to appeal this to the Court of Appeals. You understand that?
I'll see you in federal court.
Okay, I'll see you then. All right.
Good.
then.
All
all.
of you.
This was our last hearing for the day, so we'll stand in recess. Everybody have a good weekend.
You too, Judge. Thank you.
You too. Thank
Uh-huh.
you.
Good to
Judge,
see
it's
you.
it's always good to end my week with you. You have a wonderful weekend, my
Yeah,
friend.
well,
Thank you
it's
so much.
usually It's usually interesting on Fridays. I'll give you that.
This one
It's
was
nice to
different.
see how much you all know each other and are so buddy-buddy.
Okay, y'all have a good weekend.
You take it, Judge.
Thanks, Amy.
Thank you, Judge.